Oh, hello! Welcome to my bar review show. Today we're talking about torts. Torts involve specific torts, negligence, strict liability, products liability, and etc. Right now we'll be talking about specific torts. So we have specific torts, negligence, strict liability, products liability, and etc. Specific torts and defenses involves, in general, intentional torts defenses, and property interest harms. Intentional torts in general. Tortious conduct is a voluntary act or failure to act. Requisite mental state. Purposeful or defendant knows consequences substantially certain. Causation. Resulting harm legally caused by defendant's conduct. Going from in general to intentional torts. Intentional torts involves battery, assault, IIED, and false imprisonment. Battery. Defendant intends contact with plaintiff's person. Transferred intent applies. The single intent rule, which is the majority. Defendant may be liable if defendant intends to bring about contact. Defendant need not intend contact is harmful or offensive. The double intent rule, minority rule, defendant must intend to bring about contact and intend contact to be harmful or offensive. Defendant's conduct causes such contact. Indirect contact counts. Defendant's conduct must be voluntary and affirmative. Conduct causes harm or is offensive. Harmful means physical injury, illness, disease, impairment, or death. Offensive means reasonable person standard, which is objective, or when defendant knows contact is highly offensive to plaintiff's sense of personal dignity. All right, assault. Defendant intends to cause plaintiff to anticipate imminent harmful and offensive contact, and defendant's affirmative conduct causes plaintiff to anticipate such contact. Anticipated contact. No actual contact required. Plaintiff must be aware of defendant's acts. Anticipated contact must be harmful or offensive. Imminence. Future harm threats or threats made by defendant who is physically too far away do not satisfy this requirement. Intent. Subject to transferred intent. Purdue chickens can never talk shit about queens, but I do notice a lot of Purdue chickens have been trying to say the queen's name for clout. Yeah, you do. All right. IIED. Intent or recklessness. Defendant, by extreme and outrageous conduct, intentionally or recklessly causes plaintiff severe emotional distress. Transferred intent does not apply to IIED when defendant intended to commit different intentional tort, like battery, against a different victim. Instead, it's governed by the bystander rule for third-party victims. Transferred intent may apply to IIED if, instead of harming intended person, defendant's extreme and outrageous conduct harms another. Defendant's extreme and outrageous acts. These are beyond human decency. They are outrageous. Public figures or concerns. Public figure must show falsity and actual malice. Private figure cannot recover if issue was of public concern. Emotional harm caused to third party. Distresses victim's immediate family member, with or without resulting body injury, or other bystander resulting in body injury. Causation, factual cause test. Damages, severe emotional distress beyond a reasonable person's endurance, or defendant knows of plaintiff's heightened sensitivity. All right, false imprisonment. Defendant intends to confine another within a limited area. Defendant's conduct causes plaintiff's confinement, or defendant fails to release plaintiff from confinement despite duty to, and plaintiff is conscious of confinement. Confinement, limited area, or when plaintiff is compelled to move in highly restricted way. Physical barriers or force, threats, invalid use of legal authority, duress, failure to provide means of escape. Confinement's length. It's immaterial except as to the damages amount. Intent. Purposeful act or knowing confinement is substantially certain to result. Damages. Majority. Actual damages are unnecessary. Plaintiff can recover nominal and possible punitive damages. Damages. Minority. Actual damages necessary only if plaintiff was unaware of confinement. All right, going from intentional torts to intentional tort defenses. Intentional torts to intentional tort defenses. Intentional torts defenses. They involve consent, self-defense, third-party defense, property defense, minors discipline or control, protect mentally impaired from self-harm, and arrest privilege. Consent. Defendant is not liable if plaintiff gave legally effective consent, actual, apparent, presumed, or there was an emergency. Actual. Plaintiff is willing for conduct to occur, revoked by clear communication. Apparent. Defendant reasonably believes plaintiff actually consents. Presumed, implied. Defendant is justified based on prevailing social norms, or defendant has no reason to believe plaintiff would not actually consent if defendant had requested consent. Emergency. Usually medical. Conduct's purpose is to prevent or reduce risk to plaintiff's life or health. Self-defense. Defendant must reasonably believe force is necessary and proportionate to force plaintiff is intentionally inflicting. Defensive purpose. Defendant's force must be defensive, but defense need not be defendant's sole motive for force. Non-deadly force. Defendant reasonably believes that 1. Plaintiff's force is intentional and unprivileged. 2. Defendant's force is proportional. And 3. Defendant can prevent plaintiff's force or threat only by immediate force. Deadly force. Defendant reasonably believes 1. Plaintiff's force is intentional and unprivileged. 2. Defendant is at risk for death or serious bodily harm or rape. And 3. Defendant can prevail only by deadly force's immediate use. No retreat duty, majority. Before using force in defense. Withdrawal. If plaintiff withdraws, defendant no longer has privilege to use force. Initial aggressors. Generally, they're not entitled to claim self-defense. Not liable for bystander's injuries. Defendant may use non-deadly force against bystander if force plaintiff is using against defendant is substantially greater than force defendant uses against the bystander, and defendant's force use against the bystander is immediately necessary. Third-party defense. Reasonable belief the defendant party is entitled to use force to defend self, and it's immediately necessary. Property defense. Defendant is privileged to act to prevent plaintiff's immediate intrusion. Plaintiff's intrusion is not privileged. Defendant reasonably believes plaintiff is intruding or about to intrude, and defendant can prevent it by means used. Defendant asks plaintiff to stop, or such request would be useless or dangerous. The means used are reasonably proportionate to the value of the interest protecting, the value someone is protecting, and the means used are not intended to or likely to cause death or serious bodily harm. No deadly force is allowed, including deadly traps. No force allowed to reclaim real or personal property wrongfully taken. You must use a legal action. Personal property is subject to the fresh pursuit exception. Minors' discipline or control. Parents, reasonable force or confinement okay, considering child's age and behavior's gravity. Privilege may extend to one acting in loco parentis. Educators, reasonable force is okay to maintain order or safety. Protect mentally impaired from self-harm. Defendant may use force against another if defendant reasonably believes force is necessary to protect that person from death or serious bodily harm, and that person does not understand her actions, nature, or consequences. Arrest privilege. We have private actor, law enforcement officials, use of force, and merchant's privilege. Private actor. Felony arrest. Okay if crime actually committed and reasonable to suspect person arrested committed it. Misdemeanor arrest. The majority. Only if committed in arresting party's presence. Private only if peace breach. Misdemeanor arrest. This is the third party. Only if, or the third restatement. Only if misdemeanor creates substantial bodily harm risk and private actor reasonably believes police will not be able to prevent or terminate crime. Assisting police. Okay if private actor reasonably believes police need help and police conduct is or could be privileged. Intervener. Force is okay against an intervener intentionally impeding actor's privileged conduct or aiding arrestee to resist or escape. Law enforcement officials. Privilege to use force or threat or confinement to arrest or investigate, terminate, or prevent crime or enforce a law. An off-duty officer is a private actor. Use of force. Private actor or police can only use force if reasonably necessary and proportionate, for a legitimate purpose, and 3, in an arrest context, arrest intent is communicated prior to force, unless communication will be useless. Merchant's privilege. Goods or services seller privileged to use force for purpose of investigating potential theft, recapturing personal property, or facilitating arrest. Merchant must reasonably believe other has taken merchandise or failed to pay for purchase. Merchant force use must be on or immediately near merchant's premises, reasonable and of reasonable duration. Deadly force is not okay. Going from intentional tort defenses to property interest harms. Property interest harms involves chattel's trespass, conversion, land trespass, and nuisance. Chattel's trespass. Intentional interference with plaintiff's possession right by either dispossessing or using or intermeddling with plaintiff's chattel. Only intent to do act is necessary. Transferred intent applies. Law or fact mistake is not a defense. Damages are actual, use loss, and nominal damages. No use loss damages without dispossession. Compensation for diminished value or repair cost. Conversion. Intentional act. Must only intend to commit act that interferes. Intent to damage is not necessary. Mistake is not a defense. Transferred intent does not apply. Must intend to control particular property. Interference with plaintiff's possession right is exercising dominion or control. So serious. So serious it deprives plaintiff of chattel use. They base seriousness on duration or extent, intent to assert right, defendant's good faith lack, harm's extent, and plaintiff's inconvenience. Damages. Property's full value or replevin. Land trespass. Intent. Intent to enter land or cause physical invasion, not to trespass. Transferred intent applies. Physical invasion. Physical property invasion. Proper plaintiff. Anyone in land's actual or constructive possession. Necessity as defense. Private. Qualified privilege for limited number of people to enter or remain on land to protect own person or property from serious harm. Not liable for trespass, but responsible for actual damages. Public. Unqualified absolute privilege to avert imminent public disaster. Not liable for damage if actions are reasonable or reasonable belief necessity existed, even if initial entry was not necessary. Nuisance. Private, public, we'll talk remedies and abatement. Private. Substantial and unreasonable interference with another's use or enjoyment of his land. Proper plaintiff. Anyone with possessory rights in real property. Interference. Must be intentional, negligent, reckless, or result of abnormally dangerous conduct. Substantial. Offensive to average reasonable person in community. Objective. Unreasonable. Injury caused outweighs action's usefulness. All right, defenses. Regulatory compliance is incomplete defense. Admissible, but it's not determinative. Defenses. Coming to the nuisance. Does not entitle defendant to judgment as a law matter, but a jury may consider it. Public nuisance. Unreasonable interference with right common to general public. Defenses in private nuisance are generally applicable. Proper plaintiff. Private citizen suffering harm different in kind from the general public. Remedies. Damages or injunctive relief. Balance equities. Abatement. Private. Reasonable force is permitted to abate. Must give defendant notice of nuisance and defendant refuses to act. For a public nuisance, absent unique inquiry, public nuisance may be abated only by public authority. Break for a new section. You can pause the video here and come back when you like. All right, we're back. Now we're going to talk about negligence. Negligence has two main categories. We've got liability and negligence defenses. So generally speaking, the first 7 sections, elements, duty, care duty, breach or care duty violation, causation, damages, and special liability rules, all fall under the liability category of negligence. Then the defenses are the last 4 sections, which is vicarious liability, immunities, sharing liability with multiple defendants, and negligence defenses. All right, so negligence definition. Failure to exercise care a reasonable person would exercise. Breach of duty to prevent foreseeable risk to anyone in plaintiff's position. Breach must be plaintiff's injuries caused. Negligence elements. Duty. Obligation to protect another against unreasonable injury risk. Breach. Failure to meet obligation. Causation. Close causal connection between action and injury. Damages. Loss suffered. Negligence definition. Failure to exercise care a reasonable person would exercise. Breach of duty to prevent foreseeable risk to anyone in plaintiff's position. Breach must be plaintiff's injuries caused. Duty. Owed to all foreseeable persons who may be injured by defendant's failure to meet reasonable care standard. Harm to another's foreseeability sufficient to create a general duty to act with reasonable care. We'll talk failure to act, harm to plaintiff's foreseeability, special foreseeable plaintiffs, and affirmative duty to act. Failure to act. Generally, there's no duty to act. Harm to plaintiff's foreseeability. Cardozo, class. Defendant only liable to plaintiffs within foreseeable harm zone. Palsgraf, majority rule. Andrews, anyone. If defendant can foresee harm to anyone resulting from his negligence, defendant owed duty to everyone harmed, foreseeable or not. This is the minority rule. Special foreseeable plaintiffs. Rescuers. Defendant is liable for negligently putting rescuer or rescued party in danger. Rescuers can apply comparative responsibility if rescuers' efforts are unreasonable. Emergency professionals are barred from recovery if injury results from risk of job. Firefighters rule. Fetuses. Care duty owed fetuses viable at injury time. Affirmative duty to act. Exceptions to this general rule. There's no duty to act exist. No duty to act exists. That's the general rule. Now we're going to talk the exceptions. Duties assumption. Placing another in peril. By contract. By authority. By relationship, employer and employee, parent and child, common carrier and passenger. And finally, by statute imposing obligation to act. Negligence definition. Failure to exercise care a reasonable person would exercise. Breach of duty to prevent foreseeable risks to anyone in plaintiff's position. Breach must be plaintiff's injuries caused. Care standard involves reasonable person, care standards for specific defendants' classes, and land possessor standard. Reasonable person. It's an objective standard. Physical, not mental characteristics are considered in determining reasonableness. Defendant who possesses special skills or knowledge must exercise her superior competence with reasonable attention and care. Voluntarily intox person is held to same standard as sober person. child, reasonable person, child of similar age, intelligence, and experience. But child engaged in high-risk adult activity is held to adult standards. Children under 5 are generally incapable of negligent conduct. Care standards for specific defendants classes. We'll talk about common carriers, planes, trains, buses, innkeepers, auto drivers, bailor, bailee, and real property sellers. Common carriers, planes, trains, buses. Highest care duty consistent with practical operation of business. That's the majority rule. Innkeepers. Ordinary negligence is the majority, and slight negligence is the common law. Auto drivers. Absence guest statute, ordinary care to guest, as well as passengers, majority. The minority is refrain from wanton and willful misconduct. Bailor. Gratuitous. Duty to warn bailee of known dangerous defects. Compensated. Duty to warn bailee of defects bailor knew or should have known had bailor used reasonable diligence. Bailee. Gratuitous. Liable only for gross negligence. Compensated. Must exercise extraordinary care. Mutual benefit. Must take reasonable care. Real property sellers. Duty to disclose known, concealed, unreasonably dangerous conditions. Liability to third parties continues until buyer has reasonable opportunity to discover and remedy defect. So now we have standards for land possessors. We'll talk about trespassers, invitees, licensees, the modern and restatement approach, the modern and third restatement approach, landlords and tenants, off-premises victims, and real property sellers. Trespassers. Refrain from willful, wanton, reckless, or intentional misconduct toward trespassers. No spring guns. Discovered. Warn or protect against concealed, dangerous, artificial conditions. Undiscovered. Generally no duty unless owner should reasonably know trespassers are entering land. Then same duty owed licensee, majority. Attractive nuisance. Liable for trespassing kids' injuries if artificial condition poses unreasonable serious bodily injury risk, children cannot appreciate the danger, the burden of eliminating the danger is slight compared with harm risk, and owner fails to exercise reasonable care to protect the children. Invitee. Invited to enter for purposes for which land is held open or for business purposes. Reasonable care to inspect, discover dangerous conditions, and protect invitee from them. It's a non-delegable duty. Duty does not extend beyond the invitation's scope. Recreational land use. Some jurisdictions. Possessor who opens land for public for recreation generally is not liable for recreation land users' injuries unless they charge a fee or they act willfully, maliciously, or with gross negligence. Licensee. Enters another's land with permission or privilege. This would be a social guest or emergency personnel. Warn of concealed dangers known or should be obvious. Use reasonable care in conducting activities on land. No duty to inspect. The minority, the modern and third restatement approach. So this is this different one. Reasonable care under all circumstances, no invitee or licensee distinction. Jury considers fact of trespass in determining reasonable care. Duty not to act in intentional, willful, or wanton manner, causing physical harm, is the only duty owed to flagrant trespasser. Landlords and tenants. Landlord is liable for injuries in common areas resulting from hidden dangers which landlord fails to warn, on premises leased for public use, resulting from hazard caused by negligent repair, or involving hazard landlord agreed to repair. A tenant is liable for third parties' injuries due to conditions within the tenant's control. Off-premises victims. No duty for harm by natural condition, except rotting trees in urban areas. Duty to prevent unreasonable harm risk caused by artificial condition. Real property sellers. Duty to disclose any concealed and unreasonably dangerous condition. Negligence definition. Failure to exercise care reasonable person would exercise. Breach of duty to prevent foreseeable risks to anyone in plaintiff's position, and breach must be plaintiff's injuries cause. Breach or care duty violation. Proof burden. Traditional approach. Modern and restatement approach, the cost-benefit analysis. Custom, negligence per se, and res ipsa loquitur. Proof burden. Evidence preponderance. Greater probability than not, defendant failed to meet care standard, as shown by customer usage, statutory violation, or res ipsa loquitur. Failure was injury's proximate cause, and plaintiff suffered damages. Traditional approach. Compare defendant's conduct with what reasonably prudent person would do under the circumstances. It's an objective standard. Modern and restatement approach, the cost-benefit analysis. Consider foreseeable likelihood defendant's conduct would cause harm, foreseeable severity of resulting harm, and defendant's burden in avoiding harm. Custom. Custom evidence is generally admissible but not conclusive in establishing a proper care standard. Professionals. They are expected to show same skill, knowledge, and care as ordinary practitioner in the same community. Specialists are held to a higher standard. For professionals, deviation or compliance with custom is dispositive of breach. Expert must generally establish care standard unless negligence is so obvious it would be apparent to a layperson, like a surgeon amputating the wrong leg. Physicians. The majority rule is a national standard, including specialists. The minority or traditional rule is same or similar locale standard. Failure to comply with informed consent requirement is medical negligence, malpractice, unless the risk is commonly known, patient is unconscious, patient waives or is incompetent, or disclosure is too harmful. Negligence per se. Elements. Criminal or regulatory statute imposes special duty for others' protection. Defendant neglects to perform the duty. Defendant liable to anyone Defendant is liable to anyone in people statute intended to protect class. For harms of type statute was intended to protect against. Causation. Once negligence per se's elements are established, defendant is liable for injuries proximately caused by defendant's violation. Defenses. Compliance. Defenses. Compliance is impossible or more dangerous than not complying. Violation is reasonable under the circumstances. Statutory vagueness or ambiguity. Compliance with federal reg preempts common law tort action. Res ipsa loquitur. Circumstantial evidence. Does not change the care standard. Establishes inference of negligence sufficient to avoid dismissal. Plaintiff's harm would not have occurred if defendant used ordinary care, but plaintiff need not conclusively exclude all other possible explanations. Plaintiff is not responsible for injury, loosely applied in most comparative fault jurisdictions. Plaintiff's injury is under defendant's exclusive control. The modern trend favors generous interpretation of exclusivity. Many courts ignore exclusivity for product liability if the manufacturer wrapped package or it is clear negligence occurred during production. If many medical personnel had access to plaintiff during surgery in a malpractice claim, some jurisdictions presume each defendant has breached care duty unless each defendant rebuts. Negligence definition. Failure to exercise care a reasonable person would exercise. Breach of duty to prevent foreseeable risk to anyone in plaintiff's position. Breach must be plaintiff's injury's cause. Causation. Actual cause or cause in fact. But for defendant's act or omission, injury wouldn't have occurred. Most courts require causal link. Substantial factor test for conduct of two or more defendants or causes. If unclear, burden shifts to multiple defendants to prove each did not cause plaintiff's harm. Joint and several liability may apply if two or more defendants are each the factual cause of an indivisible injury, or defendants acted with common plan or design. Chance loss. Some jurisdictions. If plaintiff's recovery chance was less than 50% before defendant's conduct, can recover percentage of total damages equal to the difference between recovery chance before and after defendant's negligence. Limits on liability, proximate cause, or liability scope. Limits on liability. Foreseeability. Defendant is liable for reasonably foreseeable consequences of foreseeable type, the majority. Defendant is liable for all direct consequences. This is the minority or Andrews test. Plaintiffs who can recover. Plaintiff can recover if plaintiff was foreseeable victim of defendant's conduct. Eggshell skull rule. Extent of damages need not be foreseeable. Intervening and superseding causes. Direct cause. Uninterrupted events chain from defendant's act to plaintiff's injury. Harm type's foreseeability does not necessarily preclude liability. That's the majority rule. Intervening cause. Cause of plaintiff's harm that occurs after defendant's tortious acts. Superseding cause breaks proximate causation's chain. Defendant is not liable. Unforeseeable intervening cause is superseding cause. For instance, an act of God, a criminal act, intentional tort of third party. Negligent intervening acts are foreseeable, like medical malpractice, and may lead to joint and several liability. Negligence definition. Failure to exercise care a reasonable person would exercise. Breach of duty to prevent foreseeable risk to anyone in plaintiff's position. Breach must be plaintiff's injuries cause. Damages. We've got actual physical harm, compensatory damage, mitigate duty, personal injury, property damage, collateral source rule, and punitive damages. Actual physical harm. Must prove actual injury, personal or property injury, not just economic loss. Nominal damages and attorney's fees not permitted in negligence actions. Damages extent need not be foreseeable. Parasitic damage. If tort caused physical harm, may add emotional distress damages for negligent infliction of emotional distress claims. Compensatory damages. Make the victim whole. Mitigate duty. Not duty to defendant, but may reduce plaintiff's recovery. Personal injury. Past or future pain and suffering, medical expenses, lost wages, or reduced future earnings. Eggshell skull rule applies. Liability for full extent of plaintiff's injuries may be increased because of pre-existing condition. Property damage. Generally, difference between fair market value before injury and immediately after. Most courts allow repair cost as alternative if repair cost does not exceed property's value or replacement cost for household items. Collateral source rule. The traditional rule. Benefits from outside sources, plaintiff's insurance, are not credited against defendant's liability. Payments by defendant's insurer are credited against defendant's liability because defendant's insurance is not from a collateral source. The modern trend. Statutes have eliminated or substantially modified the rule. Punitive damages. Clear and convincing evidence of malicious, willful, and wanton or reckless behavior. Can include torts that inherently involve this mind state or behavior. Generally cannot exceed single-digit ratio to compensatory damages. All right, we did all the topics under liability for negligence. Now let's talk about the negligence defenses. Negligence definition. Failure to exercise care reasonable person would exercise. Breach of duty to prevent foreseeable risk to anyone in plaintiff's position. Breach must be plaintiff's injuries cause. Special liability rules. Negligent infliction of emotional distress, pure economic loss, wrongful death, survival actions, loss arising from injury to family member, wrongful life, and wrongful birth. Negligent infliction of emotional distress, danger zone. Plaintiff was in danger zone, feared for safety. Physical impact threat caused emotional distress. Proof. Majority. Emotional distress must be manifested by physical symptoms, nightmares, shock, or ulcers. Minority. Allow recovery without harm's physical manifestation. Bystander recovery. Plaintiff outside danger zone can recover if closely related to person defendant injured, present at scene, personally observed or perceived injury. Proof. Majority requires physical symptoms, nightmare, shock, or ulcers. Special relationship. No physical impact threat or physical symptoms required. This would be examples would be corpse mishandling or mistakenly reporting relative's death. Pure economic loss. Only recoverable with related personal injury or property damage. Wrongful death. Recoverable damages include loss of support, companionship, society, and affection, but not plaintiff's pain or suffering. Recovery is limited to what decedent could recover. Survival actions may permit decedent's estate's rep to pursue any claims decedent would have at death time, may include pain and suffering. If survival and wrongful death actions are permitted, then no double recovery is allowed. Loss arising from injury to family member. Consortium losses for spouses. Services loss for injured child. Wrongful life. Minority allows action by child for failure to perform contraceptive procedure or diagnosed congenital defect. Damage is limited to those attributable to disability. Wrongful birth. If birth is due to failed contraceptive procedure or defect diagnosis, many states permit parents to recover medical expenses for caring for disabled child. Some states allow mother to recover pain or suffering damages and medical expenses for labor. Negligence definition. Failure to exercise care reasonable person would exercise. Breach of duty to prevent foreseeable risk to any in plaintiff's position. Breach must be plaintiff's injuries cause. Vicarious liability. Employer's liability for employees' torts. Independent contractors. Business and joint enterprise partners. Car owners. Parent or child. Dram shop liability. Employer's liability for employees' torts. Occurs when employer has right to control employees' means and methods. Otherwise see independent contractors. Tort within employment scope, not liable for intentional torts unless force inherent to job or authorized to act or speak for employer and position provided opportunity for tort. Employer may be liable for detour, a minor deviation from scope, but not a frolic, unauthorized and substantial deviation. Direct liability. Negligent hiring, training, supervision, or entrustment of employees is employer's negligence, not vicarious liability. Independent contractors. Employers are generally not liable for independent contractors' torts, except for negligent selection of independent contractor, vicarious liability for non-delegable duty, or vicarious liability for independent contractor acting under a parent agency. Business and joint enterprise partners. Liable for each other's tortious conduct if committed within business purposes scope. Car owners. Car's negligent entrustment if defendant knows or should know necessity and opportunity for exercising such control. Family purpose doctrine. Defendant is liable for family members driving with permission versus owner liability statutes. Liable for anyone driving with permission. Parent or child. Vicarious liability only if child acted as parent's agent, state statute applies, or if assumed liability on child's driver's license application for negligent driving. Primarily negligent if fails to exercise reasonable care to prevent minor child from intentionally or negligently harming third party if parent 1. Can control the child, and 2. Knows or should know necessity and opportunity for such control's exercise. Dram shop liability. Many states recognize action cause against intox beverages seller when third party is subsequently injured due to buyer's intox. Most states only allow liability if buyer was minor or intoxed at sales time. Many states extend to social hosts for injuries to intoxed guests or third parties. Negligence definition. Failure to exercise care reasonable person would exercise. Breach of duty to prevent foreseeable risk to anyone in plaintiff's position. Breach must be plaintiff's injuries cause. Immunities. Government, federal and state. Government officials. Intra-family, charitable. Government, federal. Fed is traditionally immune, but now immunity is FTCA limited. Sovereign immunity is not waived for enumerated torts, discretionary function, government contractor product liability, and most traditional government activities. Immunity is waived for intentional torts committed by law enforcement officers. State. Most states waive sovereign immunity, at least partially, but acts vary. Municipalities or local government agencies usually are governed by state tort claims acts. Immunity is traditionally attached only to government functions. Public duty rule. No liability to any one citizen for municipality's failure to fulfill duty municipality owed public at large, unless special relationship creates a special duty. Government officials. Immunity applies if government official is performing discretionary law-entrusted functions, unless official acts with malice or improper purpose. No tort immunity for carrying out ministerial acts. Legislators performing their legislative functions, judges performing their judicial functions, prosecutors. Intra-family. Interspousal immunity extinguished in most states. Parent-child immunity generally limited to core parenting activities. Charitable. Eliminated or capped in most states. Negligence definition. Failure to exercise care a reasonable person would exercise. Breach of duty to prevent foreseeable risk to anyone in plaintiff's position. Breach must be plaintiff's injuries cause. Sharing liability between multiple defendants. Joint and several liability, pure several liability, satisfaction and release, contribution, and indemnification. Joint and several liability. This is the MBE default. Each defendant found liable for single indivisible harm is liable for the entire harm. Pure several liability. Each defendant is liable only for his proportional share. Satisfaction and release. No double recovery. Contribution. Tortfeasor who paid more than fair share of common liability generally can recover excess of fair share from joint tortfeasor. Can recover no more than joint tortfeasor would be liable to plaintiff for. Not generally available for intentional tortfeasors. Indemnification. Loss shift from vicariously liable tortfeasor to primarily responsible party may be based on agreement, equity, subsequent additional harm, or strict product liability. Negligence definition. Failure to exercise care a reasonable person would exercise. Breach of duty to prevent foreseeable risk to anyone in plaintiff's position. Breach must be cause of plaintiff's injuries. Negligence defenses: contributory fault, comparative fault, and risk assumption. N equals nothing, M equals maybe. N equals nothing, M equals maybe. N equals nothing, M equals maybe. Contributory fault. Plaintiff's fault is complete bar to recovery. Common law or traditional view. Not a defense to intentional tort, gross negligence, or recklessness. Last clear chance rule. It's abolished in most states. Plaintiff may mitigate legal effect of own fault if defendant had last clear chance to avoid injuring plaintiff. Defendant's actual knowledge of plaintiff's inattention is required for liability to inattentive plaintiff. Defendant liable to helpless plaintiff if knew or should have known of plaintiff's helpless peril. Comparative fault. Pure. Not complete bar to recovery. Plaintiff's damages are reduced by proportion plaintiff's fault bears to total harm. Partial. If plaintiff is less at fault than defendants combined, plaintiff's recovery is reduced by plaintiff's fault percent. If plaintiff is more at fault than defendants combined, plaintiff recovers nothing. If plaintiff and defendant are equally at fault, plaintiff recovers 50% of his total damages. In minority jurisdictions, plaintiff recovers nothing if equally at fault. Comparative fault will not reduce plaintiff's recovery for intentional torts. N equals nothing, M equals maybe. N equals nothing, M equals maybe. N equals nothing, M equals maybe. Risk assumption. Traditionally, unreasonably proceeding in face of known specific risk affects recovery. Contributory negligence jurisdiction, no recovery. Comparative fault jurisdiction, merely reduces recovery. Exculpatory clauses in contracts, these are unenforceable if disclaims liability for reckless or wanton misconduct or gross negligence, gross bargaining power disparity, exculpated party offers services of great importance or practical necessity to public, subject to typical contract defenses, or against public policy. Generally, common carriers, innkeepers, and employers cannot disclaim liability for negligence. Break for a new section. You can pause the video here and come back when you like. All right, let's talk about strict liability. Strict liability involves elements, abnormally dangerous activities, animals, and defenses. Elements: DAD, dangerous activities, animals, and defective or dangerous products. Absolute duty to make plaintiff's person or property safe. Actual and proximate causation. And damages. Abnormally dangerous activities. Not commonly engaged in. Inherent, foreseeable, and highly significant harm risk. Look to harm's gravity, places inappropriateness, and activity's limited value. Strict liability is limited to harm expected from activity. Animals. We've got wild animals, abnormally dangerous animals, and trespassing animals. Wild animals. Second restatement includes all animals not by custom devoted to humankind service, where animal is being kept. Third restatement excludes animals that pose no obvious risk of causing substantial personal injury. Owner or possessor is strictly liable for harm wild animal does, despite owner's precautions, as long as harm arises from animal's dangerous propensity characteristic or about which owner has reason to know. Owner or possessor is strictly liable for injuries caused by plaintiff's fearful reaction to unrestrained wild animal. Abnormally dangerous animals. Owner or possessor is strictly liable for injuries if owner or possessor is strictly liable for injuries if knows or has reason to know of dangerous propensities, abnormal for animal's category or species, and harm results. Owner or possessor is strictly liable for reasonably foreseeable damage caused by trespassing household pets if owner knows or has reason to know pet is intruding on another's property in a way that has a tendency to cause substantial harm. General negligence standard applies if pet strays onto public road and contributes to accident there. Trespassing animals. Owner or possessor is strictly liable for reasonably foreseeable damage caused by trespassing animal. Defenses. Contributory negligence. It's not a defense in contributory negligence jurisdictions. It does not bar recovery. Comparative fault jurisdiction. Negligence may reduce plaintiff's recovery under strict liability claim. Courts are divided. Some do not allow reduction. Risk assumption or knowing contributory negligence bars recovery. Statutory privilege. No strict liability for defendant performing essential public services. Trespassers. Property possessor. Trespassers. Property possessor is not strictly liable for injuries inflicted by his animals against trespasser, but in some jurisdictions for vicious watchdog inflicted injuries. Break 4A, new section. You can pause the video here and come back when you like. All right, we're back. Let's talk about products liability. We've got negligence, strict products liability, and warranties. Negligence, the duty. Reasonable care is owed to any foreseeable plaintiff by commercial manufacturer, distributor, retailer, or seller. Breach. Failure to exercise reasonable care in products inspection or sale. Defect would have been discovered if defendant was not negligent. Causation. Factual and proximate. Damages. Actual injury or property damage, not pure economic loss. Defenses. Contributory or comparative negligence and assumption of the risk. All right, we're moving on to strict products liability. We'll have elements, defective product, plaintiff, defendants, damages, and defenses. Elements. Product was defective in manufacturer, design, or failure to warn. Defect existed when product left defendant's control. Defect caused plaintiff's injury when product was used in a reasonably foreseeable way. Defective product. Manufacturing defect. Product does not conform to defendant's own specifications. Design defect. Consumer expectation test. Dangerous beyond ordinary consumer's expectation. Risk utility test. Risk greater than benefits, and reasonable alternative design is available. Failure to use that design rendered product unreasonably unsafe. Failure to warn defect. Foreseeable harm risk, not obvious to product's ordinary user, and risk could have been reduced or avoided with reasonable instructions or warnings. Learned intermediary rule. Prescription drug or medical device manufacturer typically satisfies duty to warn by warning prescribing physician of problems with drug or device, unless the manufacturer knows the drug or device will be dispensed without personal intervention or evaluation of healthcare provider, or in case of birth control pills. Plaintiff. Not required to be in contract privity. Anyone foreseeably injured may recover. Defendants. Must be in selling business, including manufacturer, distributor, and retail seller. If defendant provides both products and services, they're generally liable if product is consumed, not if product is only used. So a hospital is not generally liable as a defective implants distributor. Casual sellers, auctioneers, plaintiff's employer, and service providers are generally not strictly liable. Prescription drug devices retail distributors may be liable for own negligence, but only strictly liable for manufacturing defects. Damages. Personal injury or property damage. Pure economic loss must be brought under a warranty action. Market share liability. For fungible defective product produced by multiple manufacturers, jury can apportion damages based on manufacturer's market share. Defenses. Comparative fault. Plaintiff's negligence or assumption of the risk reduces recovery. Contributory negligence. Plaintiff's negligence is not a defense if plaintiff misused product in reasonably foreseeable way or negligently failed to discover defect. Assumption of the risk. Complete bar to recovery in contributory negligence jurisdictions. In most comparative fault jurisdictions, assumption of the risk only reduces recovery. Unforeseeable. User's unforeseeable misuse, alteration, or modification precludes or reduces recovery. Compliance with government safety standards. Not conclusive evidence product is not defective, but may be considered. State-of-the-art standard. Product conforms with level of scientific, technological, and safety knowledge existing and reasonably feasible when product was distributed. Compliance with state-of-the-art standard will only bar recovery in some states, not applicable to manufacturing defect claims. Statute of limitations begins to run against plaintiff with personal injury when plaintiff discovers or should discover with reasonable care his injury and its connection to the product. Unforeseeable intervening causes. All right, we're moving on to warranties. Implied warranties, merchantability. Product is generally acceptable and reasonably fit for its ordinary purpose. Fitness. Product fit for particular purpose. Seller must know purpose, and buyer must rely on seller's skill or judgment in supplying product. Privity requirements. A. The majority allows only the purchaser to recover for personal injury. B. Anyone reasonably expected to use, consume, or be affected by product may recover for personal injury only. C. Alt B, which is basically personal injury plus recovery for property damage and economic loss. So if you have a C jurisdiction, you get personal injury. You can also have property damage and you can have economic loss. Damages. Personal injury, property damage, or economic loss. Express warranties. Fact, affirmation, or promise about product. Bargain's basis part. Seller is liable for any express warranty breach, regardless of fault. Defenses. Disclaimers. Consumer goods disclaimers. Consequential damages limits for personal injury are unconscionable. Express warranty disclaimers. They're valid only if consistent with the warranty, and they're usually not. Comparative fault and assumption of the risk. Same as in strict liability claims. Comparative is negligence may reduce plaintiff's recovery. Some courts don't allow reduction. Assumption of the risk bars recovery. Contributory negligence. It's not a bar except when it overlaps with assumption of the risk. Misuse. Prevents recovery under implied warranty of merchantability when product is warranted to be fit for ordinary purposes. Claim fails if. Claim generally fails if plaintiff fails to provide seller with warranty breach notice within statutorily required time period or reasonable time period. Break for a new section. You can pause the video here and come back when you like. All right, we're back. Now we're on etc., the last section. Etc. involves defamation, privacy invasion, intentional misrep, negligent misrep, intentional interference with business relations, injurious falsehoods, and legal systems wrongful use. Defamation involves elements, libel and slander distinguished, constitutional limits on damages, and defenses. Elements. Defamatory language. Diminishing respect, esteem, or goodwill toward plaintiff. Defamatory language of or concerning plaintiff, publication, falsity, public, and fault. Of or concerning plaintiff. Reasonable third party believes language refers to particular plaintiff. Defamatory language of or concerning plaintiff, publication, falsity for public, and fault. Publication. Intentional or negligent communication to third party who understands defamatory nature. Republication identifying original speaker and uncertainty as to statement's accuracy still may satisfy this element. Defamatory language of or concerning plaintiff, publication, falsity for public, and fault. Falsity, public concern. If statement relates to public concern matter or plaintiff is public figure, plaintiff must prove defamatory statement false. Private plaintiff suing on statement that does not involve public concern matter not required to prove falsity. Defendant may prove truth as affirmative defense. Defamatory language of or concerning plaintiff, publication, falsity for public, and fault. Fault. Public figure. Actual malice. Defendant knows of falsity or reckless disregard of the truth. Private figure but a public concern matter. Defendant acted with fault, either negligence or actual malice. Private figure, non-public concern matter, at least negligence. We got defamatory language of or concerning plaintiff, publication, falsity for public, and fault. Libel and slander distinguished. Libel. Written, printed, or otherwise recorded in permanent form. General damages that compensate plaintiff for reputation harm. Generally includes radio and television. Common law allowed recovery for presumed damages. Libel per quad, if defamatory statement requires extrinsic facts proof To show defamatory statement is defamatory, plaintiff must prove either special damages or slander per se category. Slander, spoken word, gesture, or any other form other than libel. Special damages are required. Third party heard comments and acted adversely to plaintiff. Usually, but not always, economic loss. Slander per se. No special damages required if accused of committing a crime, conduct that reflects poorly on plaintiff's fitness to conduct trade or profession, loathsome disease, or sexual misconduct. General damages then permitted as parasitic damages. Constitutional limits on damages. Private person, public concern matter. Actual damages, but if actual malice is proven, punitive or presumed damages are also permitted. Private person, non-public concern. General damages without proving actual malice. Defenses. Truth. It's a complete defense. Truth, consent, absolute privilege, qualified privilege. Consent. Cannot exceed the scope. Truth, consent, absolute privilege, qualified privilege. Absolute privilege. For remarks, 1. During judicial or legislative proceedings, generally must be made by participants and related to proceedings. 2. By legislators or federal or state executive officials in official duties course. 3. Between spouses. 4. In required publications. We got truth, consent, absolute privilege, and qualified privilege. Qualified privilege. Affecting important public interest in defendants or third parties' interest. Privilege is lost if abused. Defendant's burden to prove the privilege exists. Plaintiff's burden to prove privilege was abused and lost. We have truth, consent, absolute privilege, and qualified privilege. Privacy invasion. Applies only to individuals, terminates on death. Intrusion on seclusion. Defendant's intrusive act into plaintiff's private affairs, highly offensive to reasonable person. No publication is required. False light. Facts about plaintiff's publication, or attributing views or actions to plaintiff, placing plaintiff in false light, objectionable to reasonable person under the circumstances. Truth is not always a defense in a public interest matter. Plaintiff must show malice. Misappropriation. Plaintiff's pictures or names unauthorized use for defendant's advantage. Consent lack and injury. Some states allow action to survive death. Private facts, public disclosure. Even if true about plaintiff and is not of legitimate concern to public. It's in tension with the First Amendment, so it's a disfavored tort. Damages. Emotional or mental distress proof is enough. Special damages not required. Defenses. Absolute qualified privilege for false light, public disclosure. Consent applies to all privacy tort types, but any mistake regarding consent negates defense. Truth is not a defense. Intentional misrep. False rep of material fact, generally no duty to disclose. Scienter, knowledge or reckless disregard of the truth. Intent to induce plaintiff to act or refrain in reliance on misrep. Causation, actual reliance. Justifiable reliance. Not justifiable if statement obviously is false or lay opinion. Damages, actual economic loss or consequential damages. No nominal damages, no emotional distress damages. Negligent misrep. Defendant, accounting firm or other commercial info supplier. False information, provides false info to plaintiff as a result of defendant's negligence in course of defendant's business or profession. Plaintiff justifiably relies. Plaintiff justifiably relies on info and something gets pecuniary damages as a result. Plaintiff must be in contractual relationship with defendant, or defendant knows plaintiff is member of limited group for whose benefit info is supplied. Info must be relied on in transaction that defendant intends to influence or knows recipient intends to. Defenses, standard negligence defenses. Damages, reliance and consequential. Intentional interference with business relations. Intentional interference with contract. Defendant knew a valid contractual relationship between plaintiff and third party. Defendant intentionally interfered with contract in a way that substantially exceeds fair competition and free expression, resulting in breach, and breach caused damages to plaintiff. Defenses, justified if motivated by health, safety, or morals. Contract is terminable at will. Defendant is business competition. Interference with prospective economic advantage. No contract. More egregious conduct required for liability. Should be independently tortious. Violates federal or state law. Improper conduct per balancing analysis. Business competitor will not be liable for encouraging switching business. Trade secret theft. Plaintiff owns valid trade secret, provides business advantage. Not generally known. Reasonable precautions to protect. Defendant took secret by improper means. Injurious falsehoods. Trade liable. Malicious derogatory statement published relating to plaintiff's business property title or product's quality, and interference or damage to business relationships. Special damages proof is required and mental suffering damages are unavailable. Truth and fair competition are valid defenses. Slander of title. False statements publication is derogatory to plaintiff's real property title. Malice. Special damages as a result of diminished value in third parties' eyes. Legal systems wrongful use. Wrongful legal system use. Malicious prosecution. Intentional and malicious institution of legal proceeding for improper purpose. No probable cause. Action dismissed in favor of person against whom it was brought. Damages can include legal expenses, lost work time, reputation loss, and emotional distress. Judges and prosecutors have absolute immunity from liability. Abuse of process. Legal process use against plaintiff in wrongful manner to accomplish purpose other than that for which process was intended. Willful act. Proof of damages is required. And we're done. You made it all the way through torts. Congratulations. We'll see you on the next video.